I'm Abhishek from LawTech Webinars with my colleague Jenny, and I welcome you to our first LawTech webinar of the series. Today, it gives me an immense pleasure to invite our prominent speakers, Mr. Zamir Nathani, joining us from India, and Mr. Jaroslav Jankowski, joining us from Singapore. As you are aware that today we will be discussing the topic cybersecurity threats can be fatal for organizations considering GDPR in place and the huge penalty imposed in case of infringement. Before I hand over the command to our prestigious speakers, I wanted quickly to brief you about LawTech webinars and the need to create such a platform. A very important fact I wanted to share with you is the investment, if you see in the legal tech industry, has increased 713% in 2018 as compared to 2017 and 16. So, and is further growing in 2019, which means that technology is being accepted openly across the legal sector. And with the increase in technological solutions, with the increase in going online, going cloud solutions, there comes the challenge of cybersecurity threats, which can be a very fatal thing for any organization trying to safeguard big data or the kind of customer data that they maintain. And another important thing is to help our councils to overcome the operational challenge. Many of the times, the councils are not aware. I've seen in my past organizations, councils do not know that the operational challenge they are facing because they continue to do the work in a day or in 2 days time, which can be done in within a few hours using the technological solutions.
Yeah.
So as I was telling, the purpose of creating the particular platform is to share the knowledge with the councils and basically help them be aware about the global legal industry trends, the upcoming news, the upcoming technologies that are being there. So we have basically been discussing all these things to help you understand and grow in your role and basically hear it from the horse's mouth directly from the people who have been working in the industry from last 20 years, 15, 20 years and have good amount of experience to share with you. So with this, I would like to invite Jaro to start with the presentation by briefly introducing yourself and then taking it forward from here.
Okay, many thanks, Abi, for the introduction. My name is Jaroslav. I'm having two roles in my organization, and I'm just going to lead you through the what we did in our organization and how we are addressing the cybersecurity risk in terms of the potential GDPR exposure. Since I'm both a lawyer and the manager in my organization, the legal side I'm responsible for Asia, for the continent, for both legal and compliance subjects, whereas on the business I'm responsible for Malaysia as the whole country where I drive all of the business activities. That's why I look always at the each and every challenges, both from the using my legal glasses and my management glasses, because ultimately this is all about business and how are we going to mitigate or manage the business in our organizations. And we as the legal counsels are also, I would say, strategical advisors to business, how to really handle and how to also take advantage of certain challenges, how we can maybe use it, convert the threat of being potentially penalized into that opportunity, how we can also materialize our say potential benefits stemming from that. The first subject would be basically about GDPR. I'll just give you the quick description, but I don't want to go into these details about GDPR because probably you can easily read that everywhere in the internet or in the end of the summary prepared by the law firms. But what I would like you we would like to do is like to browse you from the implication for the non-EU companies, because apparently many of the people think it is GDPR, this pure European stuff, which is, I would say, the biggest misconception that is existing on the market, because GDPR has very extensive territorial applicability. That's why I will also show you like 4 or 5 examples where also GDPR can directly or indirectly affect our businesses here in Asia, either in India, Singapore, or in China. And in the second part of my presentation, I'm going to talk about potential legal liabilities and how on the practical side, both on the legal and management side, such cybersecurity incidents should be and can be handled or addressed. Can we go to the next slide, please? Yeah, next one. So why do we start talking about GDPR? First of all, only this year we have seen a number of the very high fines that have been already imposed by the different national regulators under GDPR law in Europe. I think UK was currently taking the lead in terms of the highest fines, and they have this year in July they have tried to impose the fine on British Airways for the that is amounting to, as you see, more than 200 million dollars. The fine was is due to the fact that British Airways didn't handle properly their website, which means that the customer of British Airways, when they try to log into the British Airways and acquire the tickets, they have been diverted to the fraudulent website via the hackers, and then the hackers could harvest all of the data about the customers of the British Airways, including credit card details, name, surname, passport details, basically all what you need to complete the booking. Approximately 500,000 of the customers have been affected for the 2 up to 3 months during the 2018. And as you see, like the what the regulator said is that British Airways didn't take sufficient protection to really handle the data. Because what does it mean? According to GDPR, the personal data belongs to the individuals, which means that if you decide to run a business that is comprising of which the integral part of which is handling or processing the personal data of the individuals from the EU, then you need to also provide sufficient technological measures to protect that data. If the website of the British Airways was not sufficiently technologically protected and you allowed hackers to divert your customers to the fraudulent websites, then dear British Airways, that's your fault. That's why you need to pay for that. $230 million stands for 1.5 global turnover. 1.5% of the global turnover. So as you see, like I would say it's very hefty fine. So let's see how it will go on. But it's currently the highest fine that has been so far appeared on the European Union market. Can we go to next slide? The next one is about Marriott chain hotel. That's also, like I say, the UK regulator, data protection authority that has imposed the fine on the Marriott due to the historical events. So basically, Marriott has acquired the Starwood chain of the hotels, and they allowed for the leakage of the more than 300 million potential customers, including the 30 million customers coming from the European Union. Although there was no really like loss on the side of the individuals that have been affected by this leakage. However, again, the regulators claim that once you are the professional, is that you are supposed and you are handling the personal data of the citizens, you are required to undertake all potential and state-of-the-art solution to protect that data. You want to make money from that? You must also invest the money into protecting that data. So that was the Marriott chain. Can we go to next one? The next case was about the Google. In the Google case, it was not about hackers, so it was not cybersecurity attack, but it was from the breach of the information obligation duty that Google has not complied with. So Google basically has been collecting the personal data of the users without really like emphasizing which is the legal ground for that, what's the objective of collecting the data, etc. Which is a bit different type of the breach under the GDPR, but it gives, I would say, the picture how the different regulators and what type of the values of the fines we potentially could be exposed to. So after seeing, I would say, the 3 examples from this year, what happened in European Union, can we go to next slide? It can give you some impression that basically what's the GDPR, what does it stand for? So basically, as you could see, this is, in my view, based on what I have seen in Asia or Europe or in US, in my view, this one is the most stringent law in terms of the data privacy protection, in terms of the giving the exact rights and allowing the citizens to really get any protection from the business. Secondly, it has very broad jurisdictional reach, which means that it is this exterritorial applicability of the law. I will talk about that in the next slide, but I would like to emphasize that it is not only about European Union companies. Quite the opposite. The GDPR is meant to protect the personal data of the individuals from the EU. However, you will see that it has also much broader applicability. As you could already see based on the cases, the regulators are allowed to uh, impose very severe punishments. Basically, there are two thresholds that could be applied. One is the nominal threshold of 20 million euro, or up to 4% of the global turnover. In case, in the three of the cases I have presented, in three of these cases, the regulators have obviously applied the global turnover rate. So it was either 1.5% in terms of the British Airways, or 3% of the global turnover in terms of the Marriott chain, for the breach of the protection of the personal data. What is also the difference compared to other jurisdictions? That once any breach happens, there's also extensive notification obligation to authorities, and that exposes also the business to potential problems also in terms of the timing, because we have 72 hours to notify about violation of the processing the personal data in a legally permissible way. What does it mean? That the burden of proof has been placed on the business, that we need to prove as the business that we are complying with the GDPR. So it is sufficient for any individual or an authority to say you don't comply, and then we must prove, which means that that is very important also for the lawyers, that we need to create very good records that we are able to comply with the regulations. I'm still talking about the previous slide, but that's fine. Um, so let's go about this non-territorial application of the GDPR. There are basically four cases in which the GDPR can also apply to non-European companies. First two cases are this is the direct applicability that comes from the from the clauses that from GDPR, that would say that as long as the non-EU company or any other company in the world is processing the data of the people who are in the EU, and it offers the goods or services to these individuals, then it means that you are also directly obliged to comply with the GDPR. It is exactly the case of, for instance, international hotel chains or airlines outside of the EU that are offering business to consumer services. So they're directly addressing the, the consumers that are located within the EU. Second case that is also related to the business to consumer type of activities. This is when the non-EU company is processing personal data of the people from EU, and it target or monitor this individual behavior. So it's basically doing all of the profiling of the potential individuals from EU, such as all of these advertisement softwares that are processing what types of the website to visit, and then is collecting the data and is giving you the profile in terms of what's your, I would say, interest on the once you do the online shopping, for instance. The third type that is quite interesting, and many people are, and this is also directly the second case also comes directly from the GDPR. The third case that is very interesting, that I would say many of the people forget about that, but this is also, I would say, it is type of the indirect applicability of the GDPR that is coming from the contractual obligations that will be imposed by to non-EU companies. What does it mean? That if the non-EU company provides any type of the services to the EU companies, which means that it is business to business type of the activity, and within the course of providing that services, the non-EU company is handling the data of the individuals who are in the EU, then first of all, in order to provide such services, EU company must sign the processor agreement with non-EU company. So basically, any European Union company cannot accept services and give the personal data to non-EU company uh, if in the course of the services you are going to process the personal data without the processor agreement in place. Normally in this processor agreement, EU company would require you to comply with the whole set of the requirements and obligation that have their origins in the GDPR, which effectively means that by the contractual obligations stemming from the processor agreement, you as the non-EU company would be still required to comply with the GDPR standards and obligations. Another case when also in the B2B scenario you can be exposed to GDPR is in the event that non-EU company is developing the products for the EU market that are going to be used by the um, like within the EU. What does it mean? Like GDPR requires that the data privacy regulations would be already implemented in the course of designing any type of the products or software, which means that the data privacy and protection of the data, protection of the personal data must be already included in the course of the developing or designing products or services, which effectively means that if you want to sell ultimately the products to EU market, then that products must already by default comprise of the and must comply with the regulations that are coming from the GDPR. Otherwise, such products could be also challenged and you can be also exposed to the non-compliance or violation of GDPR. That's why here we again can talk about indirect applicability via the contractual obligations. So basically, whenever you sell the services or products that have been designed or developed for the EU market. The fourth and the last type of the situation when we could talk about the compliance with the GDPR is so-called data contamination scenario, which means that non-EU company is transferring personal data of the Indian, Singaporean, Chinese citizens to its subsidiary to another company that is located within EU. In such event, the transfer obviously is governed by your local law. But once the EU company is going to accept this personal data, is going to handle that data, then in terms of the data, then that personal data will be already subject to the protection under GDPR, which effectively means that if the European Union company would like to transfer back the data to you, then it must already comply with the GDPR, which means just because this data became within the regime of the GDPR, which it is also the case when the data can be contaminated by European Union company that is handling them. And then obviously for the retransfer of the data back to anywhere in the world, then you again need to comply with the GDPR. So as you see that with this, I would say 4 or 5 cases, you already see how exterritorial application of the GDPR can be. So which means that the more it's exterritorial, the more companies and businesses would be caught by these regulations. Can we go to next slide? So if we talk about then, as you see, like there's a extensive application of the GDPR, hefty fines for that. What does it mean in terms of the legal liabilities? Can we go to next slide, please? In terms of the legal liabilities in such event, whenever we talk about cybersecurity attack or cybersecurity violation, then obviously, except for the breach of potential, if as the consequence of the cybersecurity incident, also the personal data of the individuals are going to be mishandled, then obviously the GDPR can be, or any type on any other law about personal data can be already triggered. But it's not the end of the potential risks related to a cybersecurity incident. The 3 other legal grounds under which you can be also, or you need to also take into consideration once addressing the subject of the cybersecurity violations. It is the first one is about administrative liability that can also result from the breach of the cybersecurity obligations, which means that, for instance, in Europe, we have network and information system directives, NIC directive in the shortcut, which also imposes certain obligations on the providers of the, for instance, cloud-based solutions or on the operators of the critical information infrastructure. And then once you don't comply with that regulation, that must be with that directive that must be also implemented into the local law, then you can also be liable for the under the administrative regime for the breach of that cybersecurity regulation. The same concept also, for instance, exists in the Singapore Cybersecurity Act, under which the companies that fall under that law, obviously, whenever there's any cybersecurity act attack, and that would be proven that the attack was was possible due to the non-sufficient technological standards implemented by the company, then obviously you can also be liable under the law for that, including the administrative penalties and including potentially even criminal liability. The second type, as we said, data privacy, if the cybersecurity results into the breach of potential personal data. Third and fourth type is related to civil liability, which means that either the persons or third parties that are affected or they are suffering any loss or damage in relation to cybersecurity incidents can either submit their claims in the tort, which means that they under the local law they can still try to find a compensation for the damages that they're going to suffer, or in the event that you are also subject to any contractual obligation to preserve confidentiality of the data or to keep the data or to comply with the data privacy obligations, such as in the context of the processor agreement, then obviously by the indemnification clause or by breach of the contract, you can be also liable to such party, which I would say give you also the picture that we don't only talk about GDPR as such as the administrative regime, but we also talk about potentially civil liabilities, and in the worst case scenario, under the cybersecurity regulations, also about criminal liability for the directors. So how can we address that points? Can we go please to the next slide? So when we as the organization, when we identified that these are basically the issues, then we try to map the risks and potentially the what could be implemented by us, either on the legal side or compliance side or at the management side. So right now I'm going to show like the few of the examples of what we did or what we always advise our colleagues to apply on the legal side. And in the next slide, I'm going to show what on the management side is worth taking into consideration. Some of the things such as amending the documents, preparing the privacy notices, informing the individuals about the objectives of handling their personal data, etc. It goes without saying. But what is important here is that I would like to raise your awareness about the two subjects that are normally quite not that I would say popular. This first one is like implemented data incident management program and notification processes, and that's very important to basically have already the game plan already re-established for the purpose of potential cybersecurity attack, which means that you already define what are the processes, which are the parties that are involved, whom do you need to call, what's the chain of the command, how you are going to address on the IT level, on the notification level, on the how to handle potentially the media, etc. And that basically implementation of the data incident management plan, that's I would say the first step to move on, irrespective of what the local law would still say, to basically to make sure that your organization is definitely ready for potential cybersecurity threats. Second thing, I would definitely advise to consider whether or not buying the cybersecurity insurance also is in your interest, and to which extent it can also address some of your problems. Because basically, right now it is still a new product on the market, but if you look, depending also on the profile of your company, but if you have really potential exposure to cybersecurity incidents and potential leakage of the sensitive or important data, that can also lead to potential administrative penalties or GDPR exposure, then cybersecurity insurance, that should be something that you could also look at. Can we go to the next slide? Whereas on the management side, what is important is just basically create, I would say, I call it like partnership approach, either both with your customers or with your suppliers. So what you do, don't stay with the same problem on your side. What we did with our customers, we have been having a joint discussion with them, saying that this is the new law. You are the critical information infrastructure provider. We are your service provider. Let's look together how are we going to close the gap and how are we going to handle that, and then to create, I would say, the joint collaborative approach. So basically converting the potential threat into the opportunity to, first of all, get closer with your customers, and secondly, also to help them how to handle that potential threats. And that's something that definitely it was appreciated by our customers. And secondly, I would definitely advise, except for like obviously monitoring technological measures that you have within your organization, like what is important is to create awareness across the organization about cybersecurity risks and what is the really like the game plan, how are we going to address that, because that's the point when I would like just to remind you that there is the reverse burden of the proof, which means that the organization must prove that we did everything to protect the data, including personal data. So the records that you have been conducting any type of the awareness program within your organization, trying to sensitize your personnel about how it is important, how to handle the breaches, how to make sure that the personal data is protected. That's also the way to create good records, to potentially avoid or try to lower potential penalties if such would be imposed by the authorities. So with that one, I would like to, I think that the time is over for my part. So
And detailed discussion. Basically, we got to understand the kind of fines that has been already been imposed and the kind of implications the companies are taking, and they better need to start working on getting compliant to the GDPR. So I would like to invite the next speaker, Mr. Zamir Nathani. So he basically would be taking the discussion forward from here. Zami, could you start by introducing yourself a bit, and then we can take the discussion forward from here.
Sure. Uh, Hi, everyone. Uh, my name is Zamir Nathani, and I am a Senior Vice President and General Counsel for UFO Movies India Limited. I was General Counsel for Raymond's Limited and also General Counsel for Reliance Entertainment Digital Businesses and Balaji Telefilms. Uh, I also serviced as a law firm attorney to Eureka Forbes, LG Electronics, TCL, Motul, Ginger Oils, and many more. Presently, I'm a member of CII, National Committee on Regulatory Affairs, Chairman for Entertainment and Media, and Global General Counsel for Indian National Bar Association. Qualification-wise, I am a master degree holder in law. Apart that, I have an executive MBA from Narsi Monji Institute of Management Studies, Mumbai. Uh, Apart that, I have done my private equity and my mergers and acquisition, etc., from Stanford and London Business School. I have done my uh, program for leadership development (PLD), which is like a executive MBA of Harvard Business School, and I have some certifications from WIPO or UN. That's my introduction about it, and we can start. Okay, so while we speak on cyber security threats and GDPR, the most important part of it is that while in the prior era of GDPR, we had a lot of issues like, Facebook, where 5 million accounts were exposed because there was one small gap in the system, not basically a public knowledge, but inside a coding error, and that was taken advantage by the hackers. Post GDPR, what we see is that there are cases which are happening, but because of the penalty which can be imposed upon the companies, corporates have become very conscious about it, and I think the regime also has become a little strict about it. When I speak about India and when I used to interact with Justice Sri Krishna, who was the chairman of the data privacy law, which was drafted, the biggest concern we had is that that the data was out in the market. We had check marked on number of websites. We did not knew whether these websites had an arrangement, like for example Facebook had an arrangement with Cambridge Analytica, and therefore the controversy happened about it. So we don't know to what extent the data is there, and therefore even when GDPR considers right to forget, even if I exercise that, I am not 100% sure whether my data is still not exposed outside. And this data I'm talking about is a sensitive data. It's my banking information. It's information regarding my social security, like Aadhaar card number, for example. And so that's the security threat and the world we live in versus the GDPR which was introduced. Next one. Next slide. So these are the broad topics I'm going to discuss with you. How cybersecurity threat can be fatal to your organization. We had a case of Facebook. We had a case of Marriott. In the case of Marriott, things were happening since 2014. People were not aware about it. It was some uh, l- uh, lacklusterness in the system, which went unnoticed. We had a case of Equifax, one of the largest cyber attacks of 2017. We then speak about what measures can organization take to counter these kinds of attacks and secure the data. Uh, Apple has a new privacy portal now to comply with GDPR. Deutsche Bank has a DB secure authenticator, and how technology can provide you a solution as well as help you to defeat the attacks which are happening. How guard time, a company which services are used by governments, also uses blockchain technology to safeguard data. When we talk about blockchain technology, always remember that data is stored in block forms. Okay. uh, how there is a case study on deception, which can be a strategy for cybersecurity, because in today's world, hacking, etc., is become a very common synonym in the business affairs of technology, and how various strategy is now used so that you can mislead the hackers. Instead of saying that my systems are not hackable, there are various kinds of deceptions which are brought into the system so that the hackers are misguided and you are able to address it at the moment. What are the consequences of GDPR? Just a few highlight about it, and that's how I wrap up my session. All right, next one. Okay, so when we talk about cyber attacks, 32% of businesses have identified cybersecurity breaches or attacks in the past 12 months. This is the data of UK government cybersecurity breach survey 2019. So 32 businesses are very clear publicly that there are cybersecurity breaches and attacks which are happening. The companies can range from millions to billions, and have all the reputation at stake because of things which are happening. So we now accept this as a reality of life, that these attacks are going to happen. How do we secure, and how do we also comply with the law? Most common types of attacks which were identified were phishing, ransomware. Your system is locked, you are asked for extortion. There's a delay, DDoS attack, where there is a disruption or delay in the service. Computer viruses and attack vectors, who get into your system, hack into your system, and don't allow you to operate within the system. And this has everything to do with data itself. How cybersecurity can be fatal for organizations struggling to ensure data privacy or volumes of data when GDPR is already in force. While you try to save your data from the various cyber breaches, the other side of the coin is that if you are non-compliant, the steep fines which are implemented and imposed upon you of around 20 million euros, or around 4% of your global turnover, whichever is higher, is a very costly affair, and that can really put your organization into trouble. So one is, you have a data breach which has happened in your premises, therefore there is a loss of reputation. You are, number two, a non-compliant company, and therefore a fine is imposed upon you, and therefore it's a thrashing from four corners which is happening. That's how serious this business has now become. We always also try to see that there are circumstances which really give rise to fine, because the conceptually it is in my mind that if I make this public, I think I'm going to suffer a reputation loss, I'm going to suffer a share market loss, and therefore generally we try to work in the opposite direction of not mitigating the same, but acting contrary to that. I can tell you that companies which have been very forefront and outright in doing this disclosure have seriously benefited. Yahoo did not do that, and it really suffered the reputational loss as well as the regulatory loss. GDPR complaints also bring really a reputational damage to you, and therefore compliances is not only legal point of view, but also it's the reputation at stake. Next one. So we have our first case study on Marriott, which is, sorry, we're not sure anyone else had the same problem, but I had difficulty in connecting. Am I audible, Abhishek, or is there any trouble in the voice? You can hear me. Okay.
Yeah, all good.
All good. Okay. We are on slide for Marriott.
Just a moment.
Next one. Yeah. Okay. So we go on to our first case study on Marriott. Before this. Yeah. So it's about $123 million GDPR fine for 2018 security breach. Now, what happened in the case of Marriott is that, since 2014, there was a gap in the system. Data was hacked. Apparently, I was staying in the same hotel in New York when this happened on the same day. The company had acquired Starwood's hotel in 2016, and during the process, the technology due diligence, I think there was some gap in that. When it uncovered the data breach in September 2018, the company waited till November 2018 to report it to authorities. Marriott reported that 339 million guest records had been compromised. The regulator said that there was a gap because of the reasonable security matter which they could have taken it up. They did not take reasonable care. So the fine which was imposed on Marriott was not for the reason of some gaps in the technology. The fine which was imposed used the word that there was no reasonable care, which means your due diligence mechanism was not in place, your checks and balances were not in place, and therefore a $123 million fine was imposed. Approximately, this was 3% of the company's $3.6 billion in global annual revenue. So a big damage in terms of reputation as well as the money. Next one. So Equifax, all in the newspaper, largest cyber attack of 2017. Personal information of around 143 million consumer was compromised. Additional 209,000 credit card data was exposed. Breach was discovered in July 2017. Company actually failed to meet the 72-hour notification requirement of the GDPR when the breach happened. See, because what happens is the moment you report this to the CEO of the company, it goes into the damage control mode, But at all point of time, remember, the more delay you do in your disclosure, it's going to be more damaging. So once it comes to the CEO table, we normally think that, the moment I disclose this, I will have hundreds of notice coming in from different regulatory bodies. My share market price will get down. I will have a bad reputation, which will happen. So you need to put your reputation, your public relation office, etc., everything in place. But if you don't comply with the timelines which is given in the GDPR, the settlement offer, which was given to the 147 million consumers who were affected, was a 10-year of free credit monitoring and $125 in cash. I think this was a lighter fine as compared to if the authorities had taken a great cognizance and had really took this up. Because if you remember, the mechanism in GDPR does not restrict itself to only the attacks which have happened and the fine as a compensation. There are a lot of jurisdictions which also have prosecutions. So for example, when you have the data privacy law, which would be put in India, we have provisions for prosecution in addition to the fine which can be imposed upon you. All right? Okay. I have one question. Should I take it up right now, or can I take it up later on?
We'll take the questions at the end of the session.
Okay.
Yeah.
All right. Uh, so anybody who has questions to put in, you can just put in your questions and we'll take it up later on when we have the Q&A session which is going on. I have some more questions coming in. Okay. So what measures can be taken by the organization to counter? Sorry, you can go on the previous one. Yeah. So what measures can be taken by organizations to counter these kinds of attacks and secure the data? Uh, the established norms, is that you don't have one solution to this particular problem, because while you have system protection, you have also strategies to be put in place. So in today's world, companies also decide, where they can have one server, where they can have their backup server, and which jurisdictions are more attractive for hacking, etc. These are all the departments. So I had one presentation where it was very, we had done a study where there is a team of in a company which actually tries to see who are the great hackers who are operating in the world, and what kind of things they are doing it, etc., etc. So it's data protection has now become a complete strategy if you think from a very broad level, top level, from the big companies like Facebook and all. They have all the diligent methods in addition to the standard procedures you have. So establish strong password, have a strong firewall, install antivirus protection, update and backup programs regularly, secure a laptop, monitor diligently. There is also a provision for tracking employees. These are all standard operating procedures. I am saying today we have gone to level 10 because of the risk which is involved. All right. Now, because Google was in focus in context of GDPR, Apple tried to do a new part of it, where Apple came out with a new privacy portal in order to comply with GDPR. Apple made changes to comply with GDPR by introducing a website that shows customers exactly what personal data it is holding about them. Customers can request access to personal data, including signing history. So GDPR gives you a provision to know what kind of data is there with the person. The user has an option which is given by GDPR. The user has an option to correct the data, deactivate the account, and delete all information which is held by Apple. Before having this particular session, we tried exactly the same model on Google, which was about Google Maps. And we successfully got the feedback that even in Google Map, when you do this, Google Map will completely destroy your data, irrespective of the longevity of the number of years you have been using. So this data is now activated in compliance with GDPR and other privacy laws. All right. Next slide. Dutch Bank, banking sector has been specifically also targeted at point of time. They are the most prone to all the attacks, and they have one of the most sensitive data with them. So Dutch Bank introduced DB Secure Authenticator to ensure that it's strengthening the security around clients' online data. So DB Secure Authenticator is an app which allows users of global transaction banking online system to perform secure login and authorizing transactions. Now, this particular app has a biometric authentication, which is supported on this particular app, where DB Secure Authenticator can also has a fingerprint and facial recognition without entering the PIN. So if you see the present app which we are using for HDFC, you have got an option of your fingerprint, which is a mechanism which is available on your iPhone, that your fingerprint recognition as well as facial recognition has been established in addition to the PIN which you are inserting for security. All right. Okay. Next one. How technology can provide a solution to restrict and defeat these attacks? When blockchain was built, why blockchain is becoming famous and why Visa, everybody, is uh, very authentically into that particular process. The reason is that blockchain provides you some kind of security, which, even your general crimes can also be a hurdle to it. What I saw in the case of Nirav Modi, if you remember, there is a particular checks and balance failure which happened, and because of that particular failure, the Swift account was used by the branch personnel. And if blockchain was in place, this Swift account could not have been misused. So what blockchain does is that it divides data into blocks, and these blocks are located in different jurisdictions and have their security measures in place. When blockchain is created, it cannot be changed or altered. So for example, when the Swift code was sent by this branch personnel to a foreign bank saying that X amount of money be transferred, the blockchain would have actually restricted this particular fraud transaction. There is an emergency management team also put in place, and there are advanced detection and protection tools, including use of decoy, firewalls, IPS, web-based deception, etc. So that's the advantage of blockchain. We are looking at it. There are a lot of players in the market who are really working about it. My personal opinion is that blockchain is going to make a system, like for example, when in my company we had earlier film reels which could be easily pirated, but once you have this projector system which can be digitally managed and can be restricted by password, you have actually toned down the piracy to 70%. I think blockchain is going to have that particular effect on the financial transactions. All right, next. Guard Time, very well known. I wanted to cite this name. Guard Time is an Estonia-based software security company employed by government and enterprises since 2008. Guard Time is basically providing a service which is able to detect when a change has been made to your data and is constantly verifying the changes. So, if a hacker gets into the system, if the system finds any unusual activity which is happening today, when you see on your credit card, when you swipe something at a very unusual hour in the night, there is an automatic, these are all detection system which have been put into the computer systems, and that particular raises the flag, and that's why you get a call from the credit card department. This is to ensure that there is no discrete way to tamper with the blocks in the chain. If someone tries to alter the data, the system analyzes the whole mass of change, compares with it. So, and if that doesn't patch up together, there is a red flag raised on it. It's all happening in minutes. It's all happening in seconds. All right. Uh, there are multiple strategies. So I was once referring to the document of United States Army Cyber Security Command. One of the guys from that particular wing was also my colleague in my Harvard Business School. Uh, there's a Cyber Security Command, and they have various strategies which are put in place. Today, when I think about an hacking, it's not a general hacking today which is put in the rules. Hacking has gone to a level 10. Now, today, when you talk about a cyber security, your general hacking is a normal chat on the table I have. But today, I put various strategies in place. That strategy includes my internal security. That strategy includes my external security. That strategy includes my employees. That strategy includes my customers. That strategy includes my vendors. That strategy includes my servers. That strategy includes my various offices. That strategy includes prominent jurisdictions where crime can be committed and which are very prominent for cyber crimes. So those kinds of teams are now being built up. Now, when you use deception as one of the strategy, so what is that strategy? You put honeypots uh, in place, are intentionally vulnerable, meant to attract attackers. So today, when you are sitting in your system and suddenly an email comes saying that, so we remember all this fraud known as you have won that 1 million lottery, and click on the same to claim it. The moment you click on the same, some system is then engaged in your computer. So these are honeypots which attract you to, attack your system, get into your system. These systems basically entice attackers to attempt to steal valuable data and further scope of the target network. Uh, what has now happened? There is a second generation deception system which is put in place, which is divided into four parts. There is a decoy, there's a bait. All these are systems which will attract you to that particular website or respond to it. Today, you may also receive an email from a bank where you have a banking transaction. The email address may look very similar, but it's a decoy email to gain access to your password. That's why if you see the regulatory advertisements, they say that we will never ask you any passwords, even if it is Reserve Bank of India. So presently, if you see the Reserve Bank of India advertisements which is going on television, it says we never ask you any password, which means there is some decoy email which has been also sent from that particular system. Okay, next one. Consequences of GDPR, my final slide. See, what has happened is while GDPR has been receiving accolades, it's 4% of the company revenue, fine is excessive, if you don't comply with it, you face consequences with that. It has also made a difference to the earlier system. So basically, GDPR has effectively killed off the service that police forces internationally had provided when they rely on WHOIS system. When the WHOIS system will provide you the IP addresses, name and address of a person, so you can take cognizance, you can take action under the cybercrime, etc. My opinion is that that action still remains on the earth, because GDPR is one of the compliances of the regulation, but it does not stop anybody from taking action under any other law. Uh, One fear which GDPR also has created, and by virtue of this, the cyber criminals also get into that mode, is that they've created a fear in the companies that we'll expose you to non-compliance, you will land up having your reputational loss, paying 4% of your revenue as fine, and therefore I'm only asking 1% about it. So that it's become an extortion tool, that your fine and reputation versus what do you want to give me. uh, that's one of the consequences we see on the flip side of it. Positive change is that there's an opportunity to find out exactly what data is companies are holding on and what is being used, and you have the right to amend, delete, and right to be forgotten. So I feel on the effective side of it, GDPR or any data privacy law are a thumbs up on the protection of your personal data, which is out in the market to n number of companies, corporates, individuals. That's about me on cybercrime and GDPR. Thank you very much.